There are a couple of questions which I have received from the participants. So, first question: can you highlight few mistakes which you have seen founders and investors make during the investment, which may restrict their rights post investment? I
Uh,
think you have
Vaibhav,
covered this in the presentation, but if you could summarize it again, that will be helpful.
Vaibhav, generally investor does not tend to make any mistakes. They have money, they hire lawyers, and it is the however founders tend to make mistakes by not hiring the lawyers. Okay, or you can say that not critically going through or doing any critical analysis of the document, what that document says, what the rights investor is asking for, and what would be the situation after a period of 3 or 4 years when the business is growing, or what would the situation when the investor asks for exit. So all these things are required to be carefully analyzed by the founders at the time of executing any investment document.
If I may, just to add to, I mean, I think Abhishek already covered most of the mistakes at the time of discussing pretty much every clause. I think in general, also what we have seen sometimes, from the investor's point of view, although investors, as Abhishek rightly pointed out, they don't really make a mistake in in the transaction document. However, sometimes I think this area Abhishek already touched upon, where they want to bind the founders way too much. Now, it probably doesn't have a legal implications as much as it has the business and practical implications. Sometimes they have too many reserve rights, or they have too much rights to interfere in the business of the startup. Uh, that is something I think both the investors as well as the founders of a startup or a company has to be mindful of that. While as an investor, anybody would want to have a say in the affairs of the company, at the same time, it should not result in micromanagement of all the activities, because that's where the disputes come happen. Because if the investor is required to affirm everything or have an affirmative voting right on even a small thing, what happens is a typical investor is invested in 50 different companies, but a founder is running one company. So the founder is 100% focused on the startup, whereas the investor is not. And we see a lot of the times basically the founders are chasing the investors to get signatures on documents or get like their approval to even do small things. That is where it's a business difficulty in terms of, with all the right intentions the investor had while having those rights, the investor sometimes themselves they realize that they cannot be there to sign every agreement, or sign on every decision that the company is taking. So that's a practical issue we have seen in a number of cases. I'll give you an example where we were assisting one of the investors invest in a startup where the existing investors had so many rights where we had to chase them to even get the small documents for due diligence from the company. The startup didn't even have the right to share certain documents with potential new investors, while they had already approved that the new investment would come from our client, uh, subject to obviously the results of DD, as well as the agreement on the agreements on transaction documents. They were It took us more than 2 months just to get the documents, mainly because the investors were located in different parts of the world, and a physical signature or sign off from those investors were needed in order to just obtain those documents, or even to make small decisions by the company, even though orally they agree that they could let us do that. But it created a lot of practical difficulty, and it's just a small example. The day-to-day business affair might have several such examples.
Thank you, Pankaj and Abhishek. I think this is also for learning for the founders as well. When you are getting into an agreement,
Exactly.
make sure you don't sign on the conditions which restrict your day-to-day operations as well. Moving on to
True.
the
Yeah,
second
please go.
question, which is that we are also seeing a lot of investors asking for personal liability clause from the founders, and there have been discussions around for affirmative votings. Can you explain these to us?
Uh, so I'll just go first. So I
Yeah,
think,
Pankaj, please.
yeah, I mean, affirmative, as we already discussed, this creates a problem. You know, if there's too many affirmative rights, the investors gets, or if you allow the investor, it's bad for both. There needs to be some balance, of course, in that. So if coming to the right, where the obligation, especially it comes on warranties and representations, you have no investor would, you know, want to have the warranties and representation given by just the company. And that's not just limited to startups. Even in strategic sale or a strategic investor investing in any company, existing organization, they want the the founders or the existing shareholders to give certain warranties and representation that are jointly and separately enforceable. Now the problem with that is a lot of the times that it's difficult to enforce those, mainly because of practical reasons, especially in context of startups. Now the founders of the startups usually do not have a lot of money. Most of their valuation or their worth lies with the startup itself. Now, if you have negotiated too hard to get that, at end of the day, exit. Let's take a concrete example. Amongst the exit clauses, IPO would be one of the exit, liquidation preferences, etc. In the exit, third party sale or per sale to the founders themselves. And practically every agreement, transaction document will have, agreement will have that clause. But the problem with that is the founders usually, even the investors know that the founders will not have the money to buy back those shares from. So that's a counterproductive provision to have. Reason being that creates a lot of pressure on the founders as well as the startup to look for those exit opportunities for the investors. But sometimes the market situation is such that it does not allow for exit opportunity for the investors. At the same time, if the investors are understandable in nature, if a number of cases we see where these clauses are there, but investors do not press for exercise of these kind of rights because the practically it's not feasible to basically go ahead with the enforcement of this.
And also, at the time of on this personal liability, it is seriously advised for the founders to look for and to be diligent at the time of execution or provide execution of the agreement which provides for representation warranties, and should carefully read those representation of warranties, because the personal liability of the founders will come only in a situation where there is a breach of those representations by warranties, because investors are always on that agreement always state that investors are investing into the business relying upon those representations and warranties.
Exactly. If I could add on to that a little more, uh, if you are a founder of a startup, make sure you have given every document, every detail, every information that you are aware of about the company, even if it's a little detrimental to the valuation of the company. Reason being, uh, once you have given all the information, then the liability could be avoided basically based on the fact that there was no misrepresentation. So try to share as
And
much as information possible. At the same time, there's another way of limiting the liability uh, given through warranties and representations is by basically by way of an extra number of documents or the information shared with the investors can be basically provided there. That these are the list of documents or the information that was shared with the investors. Now, what it basically creates is that basically documents the fact this is the information that was shared with the investors. That means there cannot be any misrepresentation regarding those documents or the information given. So basically,
and
that excludes you from the liability because the investor at the time of making investment already had the knowledge of these facts.
and also adding to that, uh, as a founder you should not even hide for any probable risk in the with
Exactly.
respect to those representations, because or for the with respect to any document or information, that is also to be informed to the investor. And the common mistake which the founders do here is like they generally hide those risks in considering that the investor won't invest if I inform this thing. Investors always know and understand the risk behind the businesses. However, there are certain things which investor wants the investor to wants the founders also to disclose. And if all disclosures are there, there won't be any such kind of personal liability of the founders to come in.
Understood. Thank you for answering that. I know we have many questions from the participants. Unfortunately, we are running out of time and we are not able to take those questions as of now. We'll respond to all those questions over email. That's about it.
Yeah, we can do that. We can do that.
Once again, thank you for joining us today. We'll share the recording of this webinar as well as the presentation with all of you. Have a nice day.
Thank
And
you,
thank you
for
so much,
organizing
friends.
this. Thank you.
Thank you so much, friends, for finding a time and coming over there and attending this webinar.
Thanks, Abhishek, for sharing it. It was really wonderful to have you here.
Thank you.
Thank you.
Yeah, thank you.
Thank you, Pankaj.
Thank you, Pankaj, Abhishek. It's a good seminar.